Hi, and welcome to our webinar on the privacy update, the FTC, Congress, and the states. I'm James Cooper, professor of law here at Antonin Scalia Law School and the director of the Program on Economics and Privacy. PEP's mission, the Program on Economic and Privacy's mission is to inject sound economics into policy discussions surrounding privacy, data security, and other consumer protection and competition issues facing the digital economy. And we accomplish this by fostering research, by providing education to policymakers, and through programs like the one we have today, in which we bring together leading experts from government, industry, and academics to talk about pressing topics. We have a lot to cover today, so let me briefly introduce our esteemed panelists, and then we can get started. First, Maneesha Mithal is a partner at Wilson Sonsini. She does privacy and data security and consumer protection work. Before that, and perhaps most germane for our conversation here, she was the director of DPIP at the FTC for quite some time. Andrew Stivers is a director at NERA Economic Consulting. Before that, he was the Deputy Director of Consumer Protection in the Bureau of Economics at the FTC, and it's great to have both Maneesha and Andrew here. I was colleagues with them, and great to have you. And then last but certainly not least is Adam Kovacevich. He's the founder and CEO of the Chamber of Progress. He's certainly a veteran of tech industry policy as well, leading policy teams at Lime and Google most recently. So with that introduction, the other thing, just logistically, time permitting, we will try to have some audience questions if we do have time. So if you do have a question, please put it into the chat. And again, if we have some time at the end, I will do my best to get to this. All right. So we have a lot to cover as the description of this webinar said. I mean, we've seen a very active FTC over the last year in privacy and data security. We've also seen some activity in Congress, and we'll talk about that later. And certainly, it seems that to the extent that Congress hasn't really fulfilled some of it, actually done much of anything substantively. It seems the states have kind of jumped in to fill the void, and so we're going to talk about some of the actions in the state. But first, I want to focus on the FTC, of course, it being the lead privacy regulator here in the United States, and again having two veteran FTCers here. We want to spend a lot of time on that. So first, the FTC, as I said, has been pretty active in privacy in the wake, trying to, I would say, flex its enforcement muscles in the wake of the AMG decision a couple years ago, which took away its ability to get equitable monetary relief in federal courts for first-time offenses. It's really started to rely more on other enforcement devices where it can get money, in particular rules. And one thing I want to highlight is the health breach notification rule, which is, I would say, kind of it was part of the American Reinvestment and Recovery Act after 2009. It was kind of a little known part of the FTC's arsenal, but recently the FTC in two cases against GoodRx and Easy Healthcare has used this to actually get monetary relief from health apps and it for privacy violations. Well, and it's done this it's done this by kind of what some would say, and I don't want to be pejorative here, but some would say perhaps stretching the definition of a breach and stretching the definition of what is covered by this. So I know, Maneesha, I want to turn to you first, because I know that you have you've written about this a little bit and you've thought about this. What do you think about the FTC's use of this breach notification, and what do you think? And again, one thing I didn't mention in the lead up to this is they've actually have now a proposal, a NPRM, to modify the rule to basically codify the way they've interpreted it in these last two cases, in addition to a policy statement they put out in 2021. So this would be to actually codify the rule. So I'd like to just kind of get your thoughts on one, this approach, if it makes sense, and then if this had to be litigated, do you think that this is the kind of interpretation that would hold up either currently, even if the revised rule isn't passed, or if they do promulgate a rule with these new definitions? Is this something that, I know this is not an admin law seminar, but something that would maybe stand up to Chevron deference, given the statutory language is probably far from clear here. So Maneesha, I'm going to turn it over to you.
Okay, well, thanks so much, James. It's a really great question, and I think digital health is an area, obviously, that the FTC is very focused on. So I think we're going to see more of this type of activity going forward. You mentioned two cases. There's a third case, Better Health, where they didn't allege a violation of the health breach notification rule, but kind of this trio of digital health cases shows that this is an area of great interest to the FTC. And as you mentioned, they're doing the notice of proposed rulemaking. So maybe let me take your last question first about kind of the legal soundness of this approach. And I think there's kind of, when you look at the health breach notification rule, I think there's kind of three issues that may be somewhat controversial in the FTC's interpretation. The first is the definition of the term breach of security. I think as members of the public, we think of breaches as security breaches, but the FTC has said the breach of security is any unauthorized acquisition of personal information, and they mean acquisition of information that is not authorized by the individual. So in other words, their version of the definition includes privacy violations as well as security violations. So I think that's kind of the first controversial piece. I think the second controversial piece is the scope of application of the health breach notification rule. So when the rule was first enacted, it was intended to apply to personal health records, vendors of personal health records. And the idea was that you could go to your doctor's office, you could go to your dermatologist and your psychiatrist, and you could have one medical record that you would control, that you could input from multiple sources, and you would kind of be able to go to a new doctor and give them whatever information you chose, consumer permission data. And so one of the kind of controversial pieces of the definition is that the information has to be capable of being drawn from multiple sources. And I think the whole idea was that consumers could draw it from multiple healthcare professionals and then use the information the way they saw fit. And so I think this drawn from multiple sources has been stretched. So for example, if a consumer can have a calendar appointment or integrate email into a service, that is actually capable of being drawn from multiple sources. So I think that's the second area where I think the FTC may be stretching. And I think the third area is the scope of the information covered. The rule covers individually identifiable health information, which is defined with lots of cross-references, including a cross-reference to the term healthcare provider. So it's individually identifiable information created or received by a healthcare provider. And the FTC says, well, if you're a health app, you're a healthcare provider. Now that's somewhat controversial because we think of healthcare provider as your doctor's office or your pharmacy or your insurance company, but not as kind of the health app or the wellness app or the menstruation or fertility app. So I think in those three respects, I think the FTC's definition is controversial. I think some of them have more of a basis in the statute than others, but I think it's fair to say that those who thought they were covered by the rule and those who thought they were not covered by the rule may have to do some reevaluation unless they're willing to fight the FTC and take the FTC to court. If they did take the FTC to court, I think they would have viable arguments that this is a stretch of the rule. So I think, just stepping back to your point, James, I think they are somewhat vulnerable on this. I don't know if people are going to fight it. We'll see, if that happens going forward. But I think the last thing I want to mention is kind of the order of operations you mentioned here at the FTC. So the FTC put out a policy statement with this interpretation, I'm going to say about 2 years ago. Then they brought these cases, And now they're updating the rule. And if you think about it, it's a little bit backwards, right? So, if they're going to have a new interpretation of the rule, then maybe having the rule update first and then bringing the cases might have been kind of put the FTC in better stead. But if GoodRx or the Premom app developers wanted to fight, I think they would have had a good basis to, but it looks like they've settled. And so we'll see what happens going forward. Sorry, that was a lot of technical stuff, but
No, that's fantastic. That's fantastic. That's why we're here, and that's why we have experts. And by the way, it just dawned on me, besides me, but I'm just your host. I'm not going to be interjecting. You're the only lawyer here, so we're relying on you for all the legal advice on this call. So, Andrew or Adam, I don't. Again, Maneesha being the lawyer and gave us a great deep dive into some of the issues there. I'd love to get your thoughts on this as well, either from a legal perspective, policy perspective, or economic perspective, if you have anything to add. So Andrew,
Well,
I guess I'll turn.
Yeah, so I'll jump in as an economist who has also worked deeply in policy, both the FTC and FDA doing regulatory work. I think one of the really interesting things about information and privacy within the healthcare setting is that if you look at HIPAA and some of the earlier legislation and rules that were developed to kind of create electronic health records and that sort of thing, they're actually designed to make information flow, right? The whole premise behind that infrastructure is to push the information to those that might be able to use it. It's not about controlling it and keeping it tightly, to one particular provider or one particular area. It's really designed and intended to try to get people to share that information because of the idea that the more information that's shared about somebody's health would improve their healthcare. So, as Maneesha mentioned, stretching the definition of breach here really kind of goes against a lot of the foundational kind of electronic health rules and regulation in this area, because it wasn't really intended to control that information so much as incentivize its sharing.
No, that's that's an interesting insight. I hadn't really thought about it that way. I suppose that breach actually gives people confidence, so you share the information. If you define breach as breach, like you've got to have good security, then I feel more confident in sharing my information with you, which is the purpose behind this, is to kind of facilitate the personal health records and the use of electronic health records. But if you then stretch breach to also mean for a privacy-like definition, then maybe you're working at counter purposes, which is always the tension in privacy policy, where privacy in many ways is about clamping down information flows, and we know that information flows and a lot of times can be beneficial. So, Adam, do you have anything to add on this?
Not on this topic. No.
All right, that is humility. I like that. I like that in my. I live in the world of academics where no one is going to pass up the opportunity to talk for 30 minutes on something mundane. I
reserve the remainder of my time.
Yeah, Maneesha, did you have something to add?
Yeah, just kind of Andrew jogged a few things in my mind. I think two additional interesting things for this line of cases. One is that it was interesting that in GoodRx, Christine Wilson, the Republican who was at the FTC at the time, voted for the case and voted for the health breach notification rule count. So if you look at the GoodRx case, it is a more traditional kind of, you port over multiple records into kind of one area. And so I think that's what might have led Christine Wilson to concur in that case. Now, the last case you mentioned, the Premom case, she was gone by that time, so it was a 3-0 vote. It would have been interesting to see how she would have voted on that case. The second interesting thing that I just wanted to point out is that I think not only is the FTC being very aggressive in terms of its theories of the case, but it's also being aggressive in terms of relief. So I thought one particular piece of relief was really noteworthy, where they said, first of all, they banned these apps from engaging in targeted advertising at all. So it was a complete ban on sharing information with consumers for advertising. But they went one step further, and they said that to the extent that you're using third parties for advertising, A, provide the FTC an accounting of all third parties you're using, and B, get certifications from those third parties that they're going to not use the information for advertising purposes. So really innovative, I would say aggressive relief from the FTC. And so I think this is just an example of that.
Yeah, that's actually interesting. I knew in the BetterHelp case, which isn't really a breach notification, that I think they did a similar thing with you can't use this for advertising, which I found fascinating fencing in relief, and surprising that there was not pushback. But in a way, it's kind of using these orders, at least in the healthcare area, to say that you can't use health information for targeted ads, to make a policy that way. I think that's a really interesting insight, Maneesha. I hadn't thought about that in these other two cases. I'd missed that. That's why we have you here. Let me move on. We're sticking with the FTC again. They've been busy. I want to turn next to Andrew. And talk first. I want to talk about two things: the Kochava case and the Facebook order. But I first want to pose a question about Kochava. The Kochava was the location data broker sued under in district court for under an unfairness theory. There was a motion to dismiss that the judge granted to Kochava without prejudice, so the FTC can replead, but it was dismissed. It was dismissed because as we know, meaning all of us on the panelists here, that in order to make out an unfairness claim, you need to have actual harm or substantial, or a likelihood of substantial injury. And we can hash out what in this discussion, what that means. But the judge said that basically that the FTC had not met that pleading standard. At least they had not pled it with sufficient particularity to meet the Twombly-Iqbal standard. That yes, in theory, people could use this location data to discern sensitive information but there was actually no pleading that had actually been done, or that there was even more than just a possibility that could be done rather than a likelihood. So, I want to first talk about Kochava. And Andrew, I know you've thought a lot about, we've had discussions when I was at the FTC and we were colleagues, a lot about harm under Section 5, under unfairness, and so I'd like to get your thoughts on this as an economist and as someone who's worked on these types of unfairness cases as well. So, Andrew?
Yeah, sure. So there were sort of two parts to the judge's decision. One basically saying there is potential for harm here. And I think it's interesting, the judge did as judges do and attorneys do, which is to say, well, there have been rules in the past about privacy. And so therefore privacy must be important. And to me, he kind of backed into it. I don't know if I have the quote, but basically he said that the fact that there were rules about privacy, there were cases about privacy, meant that there was injury, and that there were prohibitions against certain kinds of sharing meant that there were injury. And of course, an economist, that's completely backwards. But it's it's a convenient way to approach the problem, and I think is illustrative of how some people have approached injury in the context of privacy. I think there's sort of two sides. One side has said, and the FTC has often fallen into this category, has simply said, well, we think it's important, therefore it's injurious, therefore, misusing it in some way is unfair. But it's sort of just a statement on faith that that injury actually exists. The other side, sometimes says, well, no, there's no injury here because, we haven't quantified it. And I say haven't quantified it as opposed to can't quantify it, because we do have tools that can allow us to estimate what injury will be. And part of that is that, you see this discussion in the law about concrete harms. And, often it's, and the other side of that is sort of, mere emotional or subjective harm. And to an economist, none of that makes any sense. We're like, well, are people either willing to pay for it or will they take costly actions to mitigate some kind of risk? If so, it doesn't matter what form the harm comes in. It's how much do people value this? What are they willing to do to avoid it? And I think that there's been a little bit of laziness in terms of the policy work that's been done, where we say, well, gosh, we can imagine all sorts of injuries, as the judge kind of pointed out here, had been done by the FTC. And there's a great paper by Danielle Citron and Dan Soloff, where they kind of imagine all the possible injuries that could come out of some sort of privacy infraction. But in terms of what happens in an individual case, whether the data at issue actually was injurious or likely was injurious, that's an empirical question that you need some sort of study, be it survey work or market studies, to be able to really figure out in any individual case.
Yeah. Well, thanks, Andrew, for that. I mean, it's, I think about, and I'd like to now open it up to Maneesha or Adam, if you have anything to add to this, because, when I think about the FTC's use of unfairness and harm outside of settlements, you've got the D-Link case, you've got the LabMD case, which won administratively but overturned by the 11th Circuit, not on harm, on completely different theory. And I'm just kind of curious where, what does this say one of the questions I'd put on the table, feel free to answer anything you want, but what does this mean for the use of unfairness as a theory and for privacy, subjective privacy harms at all going forward? So Adam, I don't know if you want to go first, and then
Sure.
I'll certainly give Maneesha a chance.
I think that it means that, frankly, if the FTC is interested in creative theories around unfairness, they might have more luck pursuing that through settlements than by testing it in court. And, I think one of the things that's interesting to me about this under Chair Khan, settlements are out of vogue. They view settlements as overly conciliatory, conceding too much to industry. Kind of the neo-Brandeisian movement views settlements as weak. And there's very much been a feeling about, well, let's, test the boundaries of the law. But, if in the Kachava case is a loss for them, and, it's not the first one on either consumer protection grounds or competition grounds. And at a certain point, if you are trying to extend the boundaries of the law by making aggressive cases that are testing the edge cases of the law, and that you're losing, you're not succeeding in that goal. So I think it calls into question whether or not this kind of what I call sort of a YOLO, you only live once, a legal strategy, whether it's actually yielding the results that its proponents want.
And just as a quick follow-up to that, you see in the state regulations often and a push to just have statutory damages, because again, people are just trying to duck this question of what the harm really is in any individual case, and just to presume it.
I'll just jump in here with a slightly rosier view of the Kachava case from the FTC, which is that I actually think there's a lot for the FTC to celebrate in this opinion. Yes, it is a loss, but there's a lot of good things in the opinion. So, for example, to Andrew's point, the court said that this privacy injury is a cognizable injury, and I think it says it squarely, and there's in a way that no case has said it like this before. So I think that's a huge victory for the FTC that a privacy injury is permissible under unfairness. I think there's some other arguments that the court dispensed with, things like, the company is not violating or about to violate the law. And the court said, well, this was phrased in the present perfect tense, so the FTC's met that bar. And dispense with some of the other arguments from Kuchava. So I think there's a lot to celebrate. I think this case really underlines, a lot of the discussions that, we all had when we were at the FTC. So the statute says causes or is likely to cause injury. So where you have even one person who said, I was a victim here, I think the FTC, under the court's reasoning, the FTC would make it. They would say, okay, there's enough to show unfairness here. But, and we made this argument in LabMD, how can you trace injury? How does the consumer know who sold their location data, or, the reason that the ultimate party has their location data? How can you possibly prove actual injury? And then you get to Andrew's point, well, you talk about maybe you prove likely injury by showing how much consumers would be willing to pay, but that's actual injury too. So, if a consumer was willing to pay something and didn't get the benefit of their bargain, that's actual injury. So what did Congress mean when it said likely to cause or causes? So you can't, again, as a lawyer in the room, you can't read out words of a statute. So there has to be something that's likely. The court said the FTC maybe proved that there's a possibility, but how do you prove that quantum of likelihood? And I think that's a real challenge for the FTC. And the court dismissed the case without prejudice, which means the FTC is likely to refile. So it'll be really interesting what additional facts they put in the complaint to try to prove likely injury.
Yeah,
And there's some
kind of been. Oh, go ahead, Andrew. Go ahead. I was just going to say to Maneesha.
Go ahead. Sorry.
Well, okay. Well, Maneesha, I was just going to say you kind of you answered my question before I was going to ask it, Maneesha. I mean, you as having been the person who would have been in charge of drafting these complaints for some time, what do you? I'm just kind of curious. I mean, obviously dismissed without prejudice. One, it seems like you think that they're going to go back and refile. And do you think that they're going to have to do additional investigation, or they kind of held some of their powder? Where are they going to get the facts that they need? What do you? I mean, I know you're speculating, but just kind of having been in this position before, I just wondered, what's going on inside the agency now?
Yeah, it's interesting. So when we tried to do this in LabMD, we got experts to explain, the likelihood of injury, and we said, okay, well, this is kind of the instances of that was an identity theft related matter. So we said, here are the instances of identity theft, and here's kind of the statistics on identity theft. I think it's interesting. I actually, frankly, think this is more a factual question, and so it's inappropriate at the motion to dismiss stage. But if I were the FTC, I would try to get, either kind of cite to consumer complaints about their location being compromised, even if they can't trace it to Kuchava's practices. I think that might show the court and give them comfort that this is not just speculative, that this can happen. And then as long as the FTC meets the hurdle. So again, for the non-lawyers, the motion to dismiss, you have to take the facts in the complaint as true, and then that's like a lower hurdle. And then in order to prove the case in court, you have to actually get expert testimony and consumer testimony or some sort of factual evidence. So I think the FTC will try to add a few paragraphs to the complaint on this likelihood issue.
And
I'm sorry, Andrew, I cut you off. Yeah.
No, that's all right. That was a good point. But I think Maneesha's discussion just there kind of, again, sort of illustrates this. I wouldn't say it's not a difficulty with the sort of empirical basis for determining harm in kind of a non-legal framework, but the court has really, as I understand it, sort of said, well, show me the guy, that like in LabMD, like connect these dots, like show me the person whose identity was stolen because of this breach, which, as Maneesha pointed out, can be really hard. There's a lot of conflating factors. You think about the tobacco cases from now quite a long time ago. There was some real difficulty there of, was your cancer caused by your tobacco, your cigarette smoking? That's a hard question empirically to answer, as opposed to did the risk of that particular cancer go up because of the tobacco smoking? And B, again, as an economist, what would you have been willing to pay to avoid that risk? Right, because that's sort of what quantifies that there is actually, in the words of the law, a concrete harm, not, can we establish that sort of rigid causal effect, right? A lot of it comes down to, what did the consumer do? What would have the consumer done if they'd had the information that we have today? And sometimes that's going to be, very little, as a lot of the research in privacy has shown, but sometimes it is going to be a significant amount.
So we could talk about harm under unfairness forever. I think. I mean, it's something been arguing about for a long time. When I say arguing, not necessarily us arguing, but it's certainly been a contentious area in this policy sphere for at least as long as I've been involved in it. But I do want to at least just briefly touch on one thing that the FTC did recently as well, that is kind of, involving remedies. And again, Andrew, I'll turn to you first, but certainly want Adam and Maneesha to weigh in if they'd like to. It's the Facebook order modification, right? And so obviously this goes back to the original 2011 or 2012, whichever the original order was, then the big $5 billion settlement in 2020, which is and then part of that settlement, as in many, there's monitoring requirements or reporting requirements to make sure you're living up to the equitable relief that you're required to do. And in response to a monitor, it's hard to tell because it's heavily redacted. At least the public version is super heavily redacted, but I guess the monitor found some problems with Facebook's compliance, and so the FTC has now said ordered Facebook, done a order show cause why they should not amend this and amend the order or modify it. And among the things that they're kind of the one of the bigger pieces of this modification is to basically say that they can't use data, they can't monetize data for anyone under 18, which now Facebook is actually is fighting this in the DC Circuit, saying that this is a DC Circuit, or I'm sorry, this is a district court, not DC Circuit. This is a district court. They have jurisdiction over it. The FTC can't unilaterally modify this. It's res judicata. We settled this. You can't go back and unilaterally modify this order. The district court owns this now, not you, FTC, and but I'm interested, Andrew, as again someone who worked there, and then I'd like to get Adam and Maneesha is what are your thoughts on this remedy, this potential remedy now in relation to the underlying conduct that got Facebook in trouble in the first place, which really didn't have to do with monetizing data. It was not a COPPA violation. It wasn't this. So what are your thoughts on that? And then I'll turn to the rest of the panelists on this.
Yeah, it's been very interesting to watch. There's, I think, two things I would say. The bigger picture, of course, in terms of thinking about this as economists, is just incentives. And so if the FTC can successfully go back and unilaterally expand an order, I think it's going to change the incentive structure for settlements going forward. People will be a lot less willing, perhaps, to pay $5 billion in the first place if they think that's not going to be holding them. The other thing that I think is very interesting, as you suggest, the demonetization of data for under 18-year-olds was not at all relevant to the way the case was put forward in sort of earlier iterations. And Commissioner Bedoya raised sort of a, hey, gosh, I'm going to consent, but I don't know about this thing. And I think in terms of how the policy, why is that important here? I think it's the FTC has a lot of experience with sort of moving the goalposts on a case-by-case basis and then stepping back and saying, well, look, here's this landscape that we've marked out. And gosh, isn't this the landscape that we should take as given? So in the context of the rulemaking that we haven't heard from in 6 months or so, but we know is going on, my feeling is that every expansion of a privacy-related order or a new element entered into an order, say with the GoodRx and that kind of thing, is really going to be something that they're strategically thinking about. What is the landscape in which we can sort of say, oh, this is perfectly reasonable. We're just codifying what's already out there.
Yeah, I mean, it's a good point, and it fits in well with what Maneesha was saying earlier. Adam, you'd like to weigh in on this?
Well, I don't think there's any doubt that I think Chair Khan is using this Facebook settlement and consent order to advance a policy objective, which is to try, I mean, not only to target Facebook specifically, but specifically to try to achieve the goal of prohibiting, monetization of teenagers. And, that I think is something that she and others have stated as a goal. Now, I'd argue that the way to achieve that goal is through Congress passing a law, or taking the commercial surveillance rulemaking or the COPPA rulemaking and proposing it through that. That would be the appropriate way of doing that. Those are hard, difficult ways of doing it, but I think actually durable ways of doing it if they follow the right steps. I don't think this is going to succeed. And I think, to me, the most notable thing here, and Andrew kind of talked about this, was the statement of Commissioner Bedoya. To date, Commissioner Bedoya has really gone along with most things that Chair Khan and Commissioner Slaughter have wanted to do at the FTC. But, on this one, the language of his statement was really, I think, kind of unprecedented in terms of recent precedent, saying, he was concerned that a nexus exists between the original order and this new demand for banning monetization of youth user data, right? And so I do think that to me, that's significant, because I think it suggests a potential gap growing between among the Democratic commissioners. Right now, it's just the Democratic commissioners. And so, disagreements among them about how far to go, to me, are like the main kind of key FTC commissioner level dynamic right now. You're not going to have dissenting minority in the Republicans, because there aren't any, but to have disagreements among the Democrats, I think, is actually pretty significant. And so I view it as significant for that reason.
Maneesha, anything to add here? I mean, this certainly does, when you think of fencing in relief, you can't, I mean, I guess anything you agree to is okay, but this is not a consent, right? So you have any thoughts?
Yeah, I mean, I was interested in raising the same point Adam did about the significance of Commissioner Bedoya's statement. And, when you go back and look, the big headline of this case for the FTC was, preventing monetization of teen data. And so then you go back and retrace the complaint and you say, okay, what was the basis for this ban? And it was some violations that seemed to occur before the before the 2020 order was finalized, and took place, and continued maybe for a period of time. And the FTC themselves called this coding errors in Messenger Kids that may or may not have taken place after the order was signed, that justify a ban on monetization of data. And so I think you could see where Commissioner Bedoya is coming from. And so I think this is, super aggressive, even for the current FTC. And I think that, reading Facebook's brief, I think they have some, really interesting arguments. And this is, of course, I don't think we said this at the top, that this is I think this is probably the first time the FTC has used this tool. And so I think this is in keeping with Chair Khan's approach of finding little, presence in the statutory language and trying to figure out ways to use it. And I think this is just another example of that.
Yeah. Well, so I looking at the clock, and I realize we have a lot to chew on in a limited amount of time. I definitely want to leave time to talk about federal and states, but I think what I'd like to move to now, and maybe Maneesha, you kind of set the stage for this a little bit, is how this fits into kind of the bigger picture, because the FTC is being super aggressive but now you've got this new Axon decision, right? And which is likely to open up the floodgates to constitutional challenges to at least administrative litigation, and clearly you can do that in federal court. So, do you think that, as someone who has been there and has run these cases, and I, having worked with you, I've always thought of you as very thoughtful and careful in that, that do you see this, and maybe I don't want this to be a leading question, but is this in some ways, this reminds me of what Adam said, the YOLO, you only live once, that hey, let's just go for it, right? I mean, yeah, we'll get constitutional challenges, and but do you think this is a little reckless? And again, I know it's a leading question, but one side you're very aggressive, but the other side, the court seems to be really, the Supreme Court and circuit courts seem to be really skeptical of independent agencies in general, and maybe the FTC in particular. So I don't know if you have thoughts, and I'd like to get others to weigh in on this as well.
Yeah, I mean, so it's interesting. So maybe just channeling my inner economist, you guys will be happy. Just in thinking about incentives, I think there's incentives for commissioners who are short timers to make big splashes and to kind of really go big, and again, not to be a skeptic, and I think and not to cast aspersions. I mean, I think the commissioners are very principled and kind of really have goals that they're trying to meet. But I think when you look at incentives, the people who vote out cases are not going to be around years down the line if those cases are struck down, or if they go to the Supreme Court, and so I think the incentives are lined up to make that immediate splash. And so I think we may be seeing some of that here. So I think that's kind of one point I'd make. And I think the other point I'd make is that I think the staff is I think sometimes viewed as like a bit conservative. In a sense, with a lowercase c, in the sense of there are a bunch of lawyers who are concerned about like the court striking down authority, so anyway, so it's just so I think that there's a feeling that like the FTC should not be as conservative among the political leadership. And it's interesting because I think there's always this argument that if we lose in the courts, Congress will step in. And Congress will fix it. Well, Congress hasn't even fixed AMG, which was kind of one of the least controversial issues. I think everybody was in agreement that the FTC should have the authority from a policy perspective to get redress for fraud and deception and things like that. So I'm very skeptical that, that we lose in the courts, or the FTC loses in the courts, and then Congress steps in to the rescue. So I don't think that's going to play out how some of the rhetoric has said, we should go big. The court strike us down, Congress will save us. I don't think that's going to happen.
Yeah. So that's, I mean, I think that's interesting when you think about Congress will save us. It's a good point about AMG. I mean, gosh, even I wrote a paper with Bruce Kobayashi saying the FTC should have the authority. I mean, maybe not full on pre-AMG authority, but some authority to get harm-based remedies. So, if you've got me and if you got Bruce and me, then you really do have everybody. But anyway, so I would like to, Adam, do you have anything to add to this?
No, I wholeheartedly agree with Maneesha in the sense that I think that you're absolutely right. A lot of times the regulators, the enforcers' best day of a case is the day the case is announced. No one's held responsible for a loss. And it's interesting to me because I think what you have colliding here is you have a lot of FTC institutionalists who are very aware of the agency's history of overreaching early 80s and being, and losing political support and losing in courts, and then really tacking to what I would call kind of a results-oriented, practical results-oriented path for years, Again, I think more recently the neo-Brandeisian movement has criticized that sort of results-oriented path as being, overly, sort of almost like accepting defeat too easily. And so that's why the rise of kind of YOLO strategy has increased. And, but if it leads to a case that shows that the FTC sets the FTC's authority back, I think that's terrible. I hate to see that. And so I do think that this is something, I do think that the martyr theory, oh, well, let's lob a bomb. Let's sue, somebody, a company that everybody hates, like, Facebook, right? Because then if Facebook wins, Congress will be so outraged that they'll just absolutely change the law. I just think that theory is almost just completely ignoring the reality of the dysfunction of Congress, right? And so I think that's wrong, but I do think that is actually some of the neo-Brandeisians' theory.
That's on that pessimistic note. Let me turn to Andrew. Anything to add?
No, I think those folks have covered it.
Okay. Well, said we're rapidly running out of time, and this will just be FTC, Congress, and the states. But I did figure the FTC would get the lion's share since we have 3 alums on this call, and they do it. But Adam, I think that what your last statement was kind of a good segue. I'd like to now kind of move to see what's going on both in the at the federal level first, and then maybe talk a little bit about what's going on in the states. I remember when I went, in the wake of the Cambridge Analytica scandal. It's the last stint I did at the FTC, and from 2018 to 19. Everybody was sure there was going to be privacy rulemaking. I think Maneesha was probably up at Capitol Hill every other day talking to people, and I think there was a lot of thought that was going to happen, but of course nothing happened. And then but now we've got the ADPPA, which at least seems to have some bipartisan traction. I think it got out of committee. I'm not an expert on this, but I think it's something where you've got at least like Marsha Blackburn and Amy Klobuchar maybe agreeing on something. Adam, I know you certainly know Capitol Hill probably better than anyone on this call. So what are your thoughts on? And I think that you kind of maybe previewed your thoughts on what Congress might do. But what are your thoughts on something like either the ADPPA or an equivalent moving through? Or do you just think that we're just never going to have a privacy bill and the FTC is on its own?
Personally, say states. This year's state sessions are mostly done. State legislative sessions are mostly done, although there's some year-round states and some states that take a little bit longer. There were a handful of additional states that passed comprehensive privacy bills this year. That adds to the kind of patchwork of state laws, although frankly, none of them are more aggressive than California. So the extent that companies are primarily centering their compliance regimes around California's, it creates more variation of compliance regimes, but not anything more aggressive. We've also seen kids bills at the state level. A number of states have passed bills. California has an age-appropriate design law. A number of states have passed more like no teens on social media type laws. On the federal level, last year, this bipartisan bill did make a lot of progress in the House. It was reported out by the Energy and Commerce Committee, but then it hit a roadblock because the California delegation of Democrats started opposing it. Why? Because the new California agency set up to enforce California state privacy law, frankly, is trying to guard its enforcement prerogatives. The federal bill is no weaker than California's law. It's actually just about as strong. But the reality is that, and it allows California's agency to enforce it as well. But, I think regulators guard their prerogatives. And so that's what was going on there. Now, it never advanced the floor. Now we have this new Congress. I think there is a chance for it to happen again. Although I think, and you're already starting to see this, that there's a lot of, demand, I think, interest in a federal privacy law. I think that'd be a good thing. But are we going to recapture the kind of the compromise spirit that happened last year where both Republicans and Democrats giving on things like preemption, giving on things like a private right of action? Just as an example, the bill last year exempted Illinois' biometrics law, BIPA. Why? Because Representative Jan Schakowsky was one of the lead Democrats negotiating it from Illinois. She wasn't going to preempt her own law. Is now the Republicans are in charge of the House, is that something they're going to go for? I just find that a little hard to believe. So I think there are kind of hurdles at every turn, and that's even before you get Senate support, where Senator Cantwell has been more skeptical of that work product. So now, having said that, I think there's also an interesting thing happening here, where there's a little bit of a high stakes game of chicken between Congress and the FTC. FTC kicked off this commercial surveillance rulemaking last year. They asked 90 some questions. They've gotten answers. They could take the next step, but I suspect that they're a little nervous about taking the next step. Chair Khan has some, inbound criticism from the House Republicans, and is it something where ideally Congress would be pushing? Ideally, Congress would be leading. If they don't, should the FTC move forward? I think it'd be good to have FTC rules, but they're going to face blowback there. So I think that's why that's probably why it hasn't happened. Why you haven't seen that next step with the FTC's proposed rules.
Interesting. I hadn't really thought about it that way, but it usually you do think of Congress as sort of leading, but here maybe Congress could sit back and do nothing, and then let the FTC take all of the publish a rule, get sued for publishing a rule, and then everybody can step back and criticize the FTC if and when they lose. So Maneesha, let me ask you about this, and since Adam kind of brought in the surveillance rulemaking into this, because in some ways I guess they are all are pieces of the same puzzle, right? I mean, do you think it really, because we do see, it was just the CCPA, but now in Virginia, there's still, I don't know how many state privacy laws there are, Virginia and Colorado and Connecticut. I think there are a couple more that I'm missing, I'm sure. Is it even workable? You, as someone, Maneesha, who counsels companies, I mean, is it even workable to comply? I mean, does it mean that you just comply with California or you just comply with Virginia or whatever it may be? I mean, can we have this patchwork? How does that work in practice for companies?
Yeah, no, so certainly that every state that passes a new law, it's incremental, additional work for clients, many of whom are small companies. And so I think you see this fascinating dynamic that I think we saw, maybe 20 years ago with state breach notification laws, where states started to pass the state breach notification laws, and industry and other groups clamored to have a federal breach notification law. And then at some point you reached a tipping point where the state laws looked fairly similar, and companies had built these compliance programs. And so I think there was some kind of there was some the foot was taken off the gas. Yeah, that's really for. So there was not as much momentum to get a federal breach law. I think you might see a similar thing happen on privacy, where now I think we're approaching 10 or at 10 states that have comprehensive state privacy laws. They're all, looking similar. I don't think, I think California, as you said, is probably the most stringent. And to the extent they all kind of look similar and, aren't raising huge additional incremental compliance costs, you might see kind of momentum die for the federal privacy legislation, or at least kind of have there be less momentum. I don't know what that tipping point is. Is it 10 laws? Is it 20 laws? Is it 30 laws? But I mean, I think, as former policymakers or current policymakers, I think, it's a shame that Congress couldn't get its act together to have a strong national privacy law, but we are where we are. So I just don't know where that tipping point is and when the momentum will wane, or maybe it has.
Yeah, no, I think that's a good point. That when you end up with enough uniformity that, certainly you can think of a patchwork, but if it's not really a patchwork and it's actually somewhat uniform with a little heterogeneity here and there, but manageable, then maybe Congress can just sit back. So Andrew, I will, you're the economist, not the lawyer or someone who works with Capitol Hill and lawmakers, but I'd like to get, kind of your thoughts, maybe in our last couple minutes here. Again, we've got this commercial surveillance rulemaking by the FTC. We've got potential of, we got this patchwork of state laws that may not be a patchwork. It may coalesce into something that's standardized. And then, and then we've got the potential of maybe federal legislation, but probably not. So, your thoughts on that as an economist, number one, and kind of as a former FTC enforcer, do you think that the FTC, Section 5, kind of, does it? I mean, I guess I've always kind of thought that Section 5 got a bum rap. That I thought it was actually used. We say, oh, it's a 100-year-old statute used on the internet. We need to update. But I think that it was used. Certainly, I've had disagreements at the margin with how it's been used, but it does seem flexible enough and to address harms, to address deception. Do you think that we even need a retool? A lot, Andrew, to answer in 3 minutes. So
yeah, no, that's a lot. I think that there's definitely space for some amount of privacy-specific regulation, rulemaking, statutes, whatever that might be. But that said, I do think that certainly my view of unfairness and deception and how the FTC has wielded it, does yield results, and they are able to go after the practices that clearly are harmful, and as we've discussed, perhaps some practices that are less clear, but they would like to go after. So, I certainly, for this kind of industry and these kinds of practices, the state level stuff makes no sense from an economic standpoint. There is no digital marketplace that only operates in a particular state, as far as I'm aware. And so, as Maneesha suggested, even if there is substantial agreement, that creates huge costs, huge compliance costs. And those are the kinds of costs that often get poo-pooed and say, oh, well, we don't actually require anything new. Well, you need to pay Maneesha or somebody like her a lot of money to figure out, are you sure you don't need to do anything new? Because if you miss something, now you've got a bunch of different states that you could have some jeopardy. And the last thing I'll say real quick is the other thing that makes that really dangerous, in my view, is the combination of private right of action with statutory damages. And we see this, I think, with the Illinois biometric rule, where it really creates an incentive to bring cases where sometimes there is going to be some injury there that they could quantify or that they could really make concrete. Other times it's just like, hey, we can get some big money here, and that's going to create some, I think, bad incentives for how firms are really trying to grapple with what the most beneficial and protective practices are.
Well, thanks, Andrew. And I guess, go ahead, Maneesha.
Quick point. I think we're seeing that point amplified on private right of action with the Washington's My Health, My Data Act, which has an extraordinarily broad definition of health, and it has a private right of action. So I think a lot of companies are going to be looking at that, because I think we've been talking about comprehensive privacy laws, but there's these kind of quote sector-specific laws, game changers as well.
Well, if there's any silver lining, it's that people will need to hire Maneesha and potentially Andrew if they need an economist. So don't push back too hard on these laws. Anyway, unfortunately, we're out of time. This has been fantastic. I want to thank the panelists for their time. I know it's valuable, and it's great for you to take some time off out of your busy days to talk about this. This has been really enlightening. It's also been great to, from a personal level, to see you guys here. And again, thanks for your time. I also want to thank the man behind the scenes, Manuel Aguilera Preto, here at the Law and Economics Center, who's works here on making this webinar happen. So thank you, Manuel. Really appreciate it. And with that, we're adjourned. Again, thanks to the panelists for a fantastic discussion.